responding to allegations of child sexual abuse. It follows the Royal Commission's 3 case studies into the Salvation Army, case studies 5, 10 and 33. Case study 5 concerned the response of the Salvation Army Eastern Territory to child sexual abuse at its boys' homes in New South Wales and Queensland. That hearing began on 28 January and was completed on 10 February 2014. The report was tabled in Parliament on 17 March 2015. Case study 10 concerned the handling of claims of child sexual abuse by the Eastern Territory between 1989 and 2014. That public hearing began on the 27th of March and concluded on the 15th of April 2014. It was completed quite close after the first case study into Salvation Army. The Royal Commission heard oral submissions in June of 2014 and the report was tabled on the 3rd of August 2015. Case study 33 examined the responses of the Southern Territory to allegations of child sexual abuse at children's homes it operated. That public hearing began on the 6th of October and concluded on the 14th of October 2015. The report was tabled in Parliament on 12 September this year. The scope and purpose of this public hearing is to consider the current policies and procedures of the Salvation Army in relation to child protection and child safe standards, including responding to allegations of child sexual abuse. Secondly, factors that may have contributed to the occurrence of child sexual abuse at the Salvation Army. Thirdly, factors that may have affected the institutional response of the Salvation Army to child sexual abuse. The responses of Salvation Army to the relevant case study reports and other Royal Commission reports, and any related matters. The purpose of this public hearing, as with the previous hearings this week, is not to inquire into individual sets of facts or particular events, as it has occurred in previous case studies. The purpose is not to examine issues of criminal justice or responses of any government agencies, each of which was considered in the previous case studies in relation to the Salvation Army. Criminal justice issues have been dealt with in other forums, most notably last week in a public hearing, and government agencies will be examined in a case study next year. A panel of representatives of the Eastern and Southern Territories will be convened and evidence will be given concurrently about the actions taken in each territory to promote child safety since the relevant case studies. The issues of redress and the responses of the Salvation Army to claims in both the Eastern and Southern Territory will be explored. As the Royal Commission and others are aware, the Commonwealth Government has recently announced a Commonwealth redress scheme, and the approach of the Salvation Army to that scheme will also be addressed. The members of the panel are Commissioner Floyd Tidd, who is the current National Commander of the Salvation Army, Lieutenant Colonel Christine Reid, who is the Secretary for Personnel for the Eastern Territory, Colonel Mark Campbell, the Chief Secretary in charge of the Eastern Territory, Ms Nikki Luady, an employee of the Southern Territory, engaged to develop and review policies in that territory. The Royal Commission will also hear evidence from a retired Salvation Army officer, Major David Eldridge, who has worked over 30 years in a variety of senior policy and program development roles in Australia and the United Kingdom. He will give evidence about the factors that may have contributed to the occurrence of child sexual abuse in the Salvation Army and that may have affected the institution's response to that abuse. The Salvation Army today is divided in Australia into 2 district territories. The Eastern Territory covers New South Wales, Queensland and the Australian Capital Territory. The Southern Territory covers Victoria, South Australia, Western Australia, the Northern Territory and Tasmania. In March this year, the Salvation Army announced that it will transition to a single national territory. Commissioner Tidd was appointed as the inaugural National Commander in Australia. His role is to act as the single leader for the two territories and to lead the unification process, which is intended to be completed by January 2019. The Salvation Army nationally no longer runs children's homes such as those considered in case studies 5 and 10. The Eastern Territory does, however, provide programs and services for children and young people under the age of 18 years. These include youth groups, extracurricular programs such as music and Bible studies, camps, clubs, childcare services, and a range of accommodation services, including crisis centres and recovery centres. The Southern Territory also provides social services to children and other vulnerable people, including foster and out-of-home care, emergency relief, support for persons suffering addiction problems and counselling. Some programs, West Care is one, are government-sponsored. The Southern Territory employs over 4,600 people and has over 10,000 volunteers administering its social welfare programs. I'll firstly deal with the Eastern Territory case studies and then move to the Southern Territory case study. The 4 Salvation Army East Territory homes examined in case study 5 provided homes for boys who were wards of the state, who had suffered from family abuse or neglect, who were sent to the homes by parents who were unable to look after them because of illness, desertion by the father, or both parents having to work. Boys who had been convicted of criminal offence or were deemed to be uncontrollable were also sent to the homes. 2 of the homes were in Queensland and 2 were in New South Wales, all closed between 1977 and 1983. Each of the homes was run in a highly regimented and authoritarian way, with some providing limited education. Former residents told the Royal Commission of brutal sexual abuse at the hands of Salvation Army officers, at times accompanied by extreme physical punishment. The Royal Commission found that between 1965 and 1977, the Salvation Army's policies and procedures were inadequate to oversee managers who were, in some cases, involved in abuse. The Salvation Army did not have clear policies for reporting allegations of criminal offences to the police, and their policies and procedures for oversight of managers did not enable the prevention or detection of child sexual abuse or excessive punishment. Case study 10 examined the Eastern Territory's handling of claims of child sexual abuse between 1989 and 2014. The Royal Commission found that in a number of claims it examined, the Salvation Army did not clearly explain to claimants the claims process to be followed, the matters that should be addressed in a victim's impact statement, and the basis upon which ex gratia payments were to be calculated, and whether or not claims were to be treated alike. In a number of the claims examined, the Salvation Army did not give the claimant an opportunity to respond to information obtained that was adverse to their claim. If adverse information was obtained, the Salvation Army inevitably made a lower offer. The Royal Commission found that the Salvation Army did not clearly indicate to claimants the steps that it would take to discipline officers or members who were implicated by the claimants. It was also found that at that time the Salvation Army required the claimants to enter into a deed that released it from liability for the abuse suffered without being encouraged to seek independent legal advice on the effect of the deed or being offered money for seeking that advice. A number of claimants said that they accepted the amount of money offered and signed the deed of release with a sense of resignation. In July this year, the Royal Commission published 10 elements which should be present in a child-safe institution. Those elements are Child safety is embedded in institutional leadership, governance and culture. Children participate in decisions affecting them and are taken seriously. Families and communities are informed and involved. Equity is promoted and diversity respected. People working with children are suitable and supported. Processes to respond to complaints of child sexual abuse are child-focused. Staff are equipped with the knowledge, skills and awareness to keep children safe through continued education and training. Physical and online environments minimise the opportunity for abuse to occur. Implementation of child safe standards is continuously reviewed and improved. And finally, policies and procedures document how the institution is child safe. These proposed child safe elements allow institutions flexibility in their application. The Royal Commission's final report will include a volume dedicated to making institutions child safe. This will include a more detailed explanation of the child safe elements and the Royal Commission's recommendations on the way in which institutions, governments and communities can better protect children. There will be evidence today from Commissioner Tidd and Lieutenant Colonel Reid about the steps taken to put in place policies and procedures to make the Salvation Army a child-safe institution. There will be evidence that the Eastern Territory has addressed each of the child-safe elements apart from equity and diversity, and that will be a matter taken up with the panel today. Commissioner Tidd and Lieutenant Colonel Reid are expected to give evidence of the following actions taken by the Eastern Territory. These are the ones that have occurred after the public hearings. Firstly, the setting up of the Way Forward Working Group in May 2014 after case studies 5 and 10 to respond to issues that arose during the course of those case studies. The restructure and reform of the Salvation Army's Professional Standards Office, including the change of name to the Centre for Restoration. The formation of a National Professional Standards Council to work to develop uniform redress principles. Convening a roundtable of independent experts to examine the question of why abuse occurred at the homes operated by the Salvation Army. And as I indicated earlier, there will be an additional witness to address the question of why in relation to the Salvation Army. Changes made to the Eastern Territory's policies and procedures for responding to sexual abuse have been made. There have been amendments to the claim processes, including the appointment of a panel of independent external investigators. There will be evidence of the process that's followed and the criteria applied in respect of claims handling now in the Eastern Territory. There has been a conduct of a review and audit of all current and closed claims files that resulted in recommendations that have ultimately been accepted. There's also been consultations by the leadership to ensure information sharing with relevant agencies, including the Police and Ombudsman. It is anticipated that the Royal Commission will also hear evidence that since 2014, the Eastern Territory has re-investigated a number of retired officers, the subject of allegations before the Royal Commission. As a result, 8 retired officers have been dismissed from the Salvation Army and their names removed from the roll. These officers are not permitted to wear the Salvation Army uniform and can only attend the Salvation Army activities or premises under supervision. 1 officer resigned before we could be dismissed. 1 officer died during investigation. His name is to be removed from the soldier's roll in any event. And the investigation into 1 officer has been suspended before a police investigation is completed. The Royal Commission will hear evidence from Commissioner Tidd and Lieutenant Colonel Christine Reid regarding the changes and restructure to what is now known, as I indicated earlier, the Centre for Restoration, and how the claims process is approached and the outcomes of the claims following case studies 5 and 10. The Eastern Territory has established a safe Salvos model, and through that safe Salvos model has implemented the 10 child-safe elements, or indeed most of those child-safe elements through that model. The Eastern Territory has acknowledged in the material provided to the Royal Commission that aspects of child empowerment and participation is an area that requires further development, in particular children having access to sexual abuse programs in relation to prevention. The Safe Salvos approach includes policies and procedures in relation to training, and in particularly an online electronic communication set of guidelines which set out the rules using those forms of communication. From the perusal by staff of the Royal Commission of the policies provided by the Eastern Territory, as I indicated before, the issue of equity and diversity may need more attention. The Safe Salvos policy doesn't outline how that framework addresses children with particular vulnerabilities, including those from Aboriginal and Torres Strait Islanders and from children who have a disability or are from culturally and linguistically diverse backgrounds. The Eastern Territory has itself identified this as a gap. Information relating to the accessibility of complaint handling process for staff and volunteers is another area in which improvement is required and, as I understand it, will be undertaken. Turning now to the Southern Territory, case study 33 concerned the response of the Southern Territory to allegations of child sexual abuse at children's homes that it operated. Now, the Salvation Army's international headquarters in London publishes orders and regulations that apply to all Salvation Army officers and soldiers throughout the world. The policies and procedures of each territory must comply with those orders and regulations. All policies and procedures at the divisional or social services level similarly must comply with those orders and regulations and the policies and procedures of each territory. Accordingly, each of the policies set at an international level needs to be applied to the local level in relation to the orders and regulations. The Royal Commission found that before 1990, apart from those regulations, the Salvation Army had no practice of maintaining written policies and procedures for its social welfare programs. In particular, it did not have policies or procedures which governed how to handle and respond to complaints of sexual abuse. In many instances where knowledge of physical or sexual abuse was brought to the attention of the Southern Territory, it failed to follow its own orders and regulations. Commissioner Tidd accepted during his evidence at that public hearing that the Salvation Army failed to follow its orders and regulations, and in doing so failed to protect children in their care. The Royal Commission found that in failing to take action against its staff and officers who were breaching those orders and regulations which prohibited the mistreatment of children, the Southern Territory provided a culture in children's homes in which children felt afraid to report sexual abuse, children felt powerless to resist the maltreatment, and staff and officers whose behaviour was in breach of orders and regulations were able to and did continue the prohibited behaviour. The Royal Commission found that on receiving claims of child sexual abuse in the early 1990s from former residents in Southern Territory homes, the Southern Territory did not adopt advice it had received from its lawyers to establish an advisory committee to resolve claims and develop expertise in child sexual abuse. It did not establish an independent panel of counsellors as a referral network for claimants, and it did not seek to obtain formal expert advice, other than legal advice, on how to handle and respond to allegations of child sexual abuse which may well have informed their policies and procedures. The Royal Commission also found that before 1997, the Southern Territory's failure to develop a model scheme for resolving former residents' claims undermined its ability to respond to those claims in a consistent manner. The Royal Commission found that some claimants who gave evidence reported that the model scheme was legalistic, and it failed some claimants because, firstly, the claims process required the assessment of factors and the provision of medical reports, similar to that a lawyer engaged in personal injuries litigation would obtain. However, the amounts paid by the Southern Territory did not aim to compensate the complainant, but were akin to redress and ex gratia payments. Secondly, the generic apologies provided by the Southern Territory before 2013 did not specifically acknowledge and accept that abuse had occurred. Thirdly, the Southern Territory did not initiate offers of counselling to claimants who were legally represented. And finally, members of the Southern Territory were not routinely present at settlement conferences, and negotiations were invariably conducted by lawyers. The Royal Commission also received evidence that the Southern Territory relied on the defence that as an unincorporated body it could not be sued. They referred to as the Ellis defence. Limitation defences were formally pleaded in all proceedings issued against the Southern Territory in South Australia and Victoria. In addition, the Southern Territory did not admit vicarious liability for the criminal or illegal acts or omissions of its employees. The Royal Commission was satisfied that in relying on these technical defences, the Salvation Army's Southern Territory placed claimants at a disadvantage. Claimants may have been prepared to accept a settlement offer that they would not have otherwise accepted. In light of Commissioner Tidd's evidence that he had directed the Southern Territory to review certain categories of settled claims, the Royal Commission found that the review should focus on all claims settled at a time when the Southern Territory relied upon those technical defences. The Royal Commission accepted Commissioner Tidd's evidence and found that in the absence of policy or procedure, by not reporting allegations of child sexual abuse to the police, the Southern Territory did not willfully conceal allegations of child sexual abuse. However, as conceded by the Commissioner, by not reporting allegations of child sexual abuse to the police, it had the effect of concealing child sexual abuse and protecting the alleged perpetrators. The Royal Commission found that before 2014, the Southern Territory failed to hold some officers accountable for their actions in sexually abusing children. Now, as indicated in other case studies this week, the Royal Commission advertised nationally for those who wish to make submissions in relation to the current policies and procedures of various institutions, including the Salvation Army. The Royal Commission received 6 submissions from legal representatives of survivors and survivor advocacy groups in response to that advertisement. All the submissions related to the process of the Southern Territory's review of claims announced by Commissioner Tidd at the public hearing in October last year. The issues raised included poor advertising and communication about the claims review process, a lack of transparency and consultation about the process, a lack of information or detail of the criteria applied in the review process, particularly how top-up payments were derived. The significantly low proportion of claims identified for top-up payments was submitted, as was that there was no information as to whether, consistent with the findings of the Royal Commission, the review of settled claims focused on all those claims settled at the time the Salvation Army relied upon those technical defences. These matters will be addressed in this hearing, including a report that was prepared for the Salvation Army in relation to that claims review. The Royal Commission also requested the Southern Territory provide details on the actions it has taken following case study 33 to address the findings. It is acknowledged that the Southern Territory has had a short period to consider those findings, as the report was tabled in Parliament in September this year. Commissioner Tidd is expected to give evidence that since the public hearing in October 2015, the Southern Territory has taken steps to address the following areas: redress policies and procedures, including creating a new role of pastoral care officer for care leavers, and changes to orders and regulations, including compliance governing the conduct of staff, officers and soldiers of the Salvation Army. Commissioner Tidd is also expected to give evidence that in recent times the two territories have adopted a more coordinated approach, particularly in relation to the development of policies and procedures. This includes the establishment of a National Professional Standards Council. Further, the Southern Territory has adopted a Keeping Children Safe policy, which is founded on the principles that sexual and physical abuse is a crime and will be reported to police, and the interests and well-being of children will always be placed above the interests of any other individual or the organisation itself. One of the Southern Territory's Keeping Children Safe standards requires that children have access to opportunities to express their views and feelings, to give opportunity about their rights and child safe practices, and how to raise concerns about abuse, suspected abuse or concerns. These matters also go to one or more of the Royal Commission's elements. The Southern Territory has also acknowledged the important role that families play in children's development, another aspect of the Royal Commission's child safe elements. Its policies and procedures indicate that its officers regularly consult and communicate with parents and guardians relating to issues concerning their children's safety and well-being. The Southern Territory has told the Royal Commission that it has consulted with communities to develop policies and procedures. The Southern Territory, unlike the Eastern Territory, also has a focus on equity and diversity, recognising children's diverse backgrounds, especially Aboriginal and Torres Strait Islander children and children with disability. The recruitment and training of the Southern Territory is also child-focused, again consistent with another of the Royal Commission's 10 elements. The Southern Territory has a detailed integrity screening process in place and conducts relevant risk assessments of workers. One of their Keeping Children Safe standard is designed to ensure that all workers are screened and recruited appropriately and in accordance with the various policies. The Southern Territory also has a child-focused complaint process with detailed procedures on reporting abuse, and their policies contain flowcharts which make it easier, we're told, for children to follow the process. Areas which may warrant further consideration by the Southern Territory include looking at the physical and online environment. There is not much material on how risks in the physical environment are identified and mitigated or managed, similarly in relation to the online environment. The involvement of children in decisions, processes and structures of the organisation is also an area which the Southern Territory might further consider. As indicated earlier, it is proposed by the Salvation Army that there will be one national territory. The consistent and national approach which should come with that restructure should help the Salvation Army improve its child safety standards through collaboration and information sharing. Now, turning to redress, during the public hearing in Case Study 33, Commissioner Tidd gave evidence that the Salvation Army supports a national redress scheme for survivors of child sexual abuse and that it would cooperate with the Commonwealth Government as necessary and comply with any requirements of a national redress scheme as implemented by the Commonwealth, including monetary levels of redress that may be prescribed or assessed within that national scheme. In relation to the Royal Commission's recommendations in its Redress and Civil Litigation report for interim arrangements, Commissioner Tidd indicated that the Southern Territory will assess any new claims for redress by reference to those principles as set out in the Royal Commission's report. A key aspect of this hearing will be the current process followed by the Southern and Eastern Territory in relation to claims handling, as that has been a key focus of those who have engaged with the Royal Commission about the Salvation Army and its current processes. It might be a convenient time for a short adjournment.
Yes, very well. We'll take the adjournment.